I bring my greeting to Dr. Mukris, my lecturer of Law of Evidence 1. My name is Heng Ek Z with metric number 254807. So in this video, I will present about my assignment 4, which is on the case of Sunny Ang against PP. So now, let's start with a case fact. This is a federal court appeal case in which the appellant, which is Sunny, was convicted on 18th of May in the year of 1965. He has been charged for murder of the victim, which the name was Jenny, had been sentenced to death. And on 27th of August 1963, at approximately 5 p.m., the appellant hired a sampan from a boatman named Yusuf. And Yusuf had subsequently taken them to the sea that near two islands, which called Pulau Dua, or famously known as Sisters Island. The appellant alleged that the purpose for going there is just to collect corals. Meanwhile, Jenny was going there to assist him as his assistant. The prosecution contended that this was mere an ostensible reason for going there. The real intention was to murder Jenny. The appellant assisted Jenny to put on all the diving equipment before Jenny dived into the water. And the appellant even allowed her to dive alone as a novice or a beginner diver. It was proof that the flippers worn by Jenny has been previously cut, and the diving area appellant ought to know was very dangerous and hazardous as a master of diver. As a result, Jenny met her death in the water. In my feeling, I personally agree with the decision that ruled by the federal court, which is to dismiss the appeal by Sunny. The prosecution is wholly depends on the circumstantial evidence because the dead body was not found at all. In this case, all the circumstantial evidence are interrelated among each others. And it is also strong to prove that the intention by the appellant, even without the presence of direct evidence, means the mens rea has been proven by the prosecution. Also, the appeal by appellant was dismissed because no substance in any of the grounds that contended by the counsels of the defense. Either jury of the judge during this trial are acted adequately and also rationally when deciding the judgment. The jury were reminded repeatedly throughout the summing up of the matter that facts were for them to decide. And besides, the judges in his passage drawing attention of the jury more than one time that such case was solely dependent on circumstantial evidence only. The cumulative effects of all the evidence leads to the irresistible conclusion that it was the accused who actually committed this crime, committed this murder. And also the circumstantial evidence were added all together, considered, and not merely each one of itself. For me, all of the cumulative circumstantial evidence lead me to the conclusion that the accused was intentionally planned for all the steps in order to murder Jenny. Next, I will proceed with the evaluation or the analysis of this case. First of all, I will start with the meaning of circumstantial evidence. As according to Blackstone's Criminal Practice 1991, circumstantial evidence is said to be contrast with direct evidence. And circumstantial evidence is an evidence that relies fully on an inference to connect it into the conclusion of a fact. For example, the fingerprint during the scenes of a crime. In the position of Malaysia, Section 5 of the Evidence Act 1950 has provided that the admission of relevant facts. In a situation where a circumstantial evidence is relevant, then it shall be made admissible by the court. In this case, firstly, the appellant was bankrupt in October of 1962, which is before or prior to the day of incident, and even still in the status of bankruptcy on the day of the accident. And the money or the insurance indemnity, insurance compensation could be the main motive of this crime. In the case of PP against Sarjit Kaur Najar Singh, circumstantial evidence is the circumstances surrounding an offense which a fact of issue may be inferred. It may include motive, preparatory acts to the commission of the offense, fingerprints, possession of the stolen goods, or even the presumption of facts. Subsequently, on 27th of August, Jenny was insured of a total of $450,000, and one of the insurance that worth $150,000 was renewed by the appellant on behalf of the Jenny. However, in this case here, the appellant did not renew his own insurance premium. And this could be a circumstantial evidence to the motive of the appellant. Next, Jenny had made a will on 7th of August, and the appellant accompanied her to the office of solicitor in order to prepare the will with the appellant's mother as a sole beneficiary. In Ahmad Najib Aris against PP, circumstantial evidence consists of all the surrounding circumstances, which comprises a series of undesigned, unexpected coincidences that, as a reasonable person, you will find your judgment is compelled into one conclusion. So as a novice or beginner diver, Jenny had only a little or a very new to the diving, and it was known by the appellant. The appellant was then allowed Jenny to dive into the water alone. As according to the expert witness in the court, it is very dangerous for a novice scuba diver to dive alone in the area there. The appellant dived there before and should be in a position to know this fact. In addition, appellant did not go down into the water even after Jenny failed to go back to the water surface after a very long time. And during that time, Jenny even did not wear gloves when went into water. And this could be a clue, because 2 pairs of the gloves were found in the appellant's swimming bag even after the disappearance of Jenny. Because as what appellant contended before, the purpose of going there is just to collecting the corals. This can prove the appellant is not intends to go there for collecting corals since the very beginning. And also the strap of one of the flippers worn by Jenny was cut into 2 places with bad intention or maliciously, even though there is no direct evidence to show that this is appellant or who cut it. But in PP against Patanaban Nalianan, circumstantial evidence as opposed to direct evidence is allowed and will be regarded as sufficient under the law in order to prove a case and sustain a conviction. Again, as according to the expert witness during the trial, when a diver suddenly loses one of his flippers while scuba diving, his equilibrium will be very upset and his mobility impaired, and it may lead to the panic in the case of a novice diver or an inexperienced diver such as Jenny. The appellant's conduct was lack of urgency after the disappearance of Jenny, as according to the boatman that I mentioned just now, Yusuf. With less than 24 hours after the disappearance of Jenny, the appellant had made a formal claims on the 3 insurance companies which covering Jenny's against incident, which was continued by the appellant before this. In Behaven and Stanson Peerage, circumstantial evidence is said to consider the weight which is to be given to the united force of all the circumstances when put together. Therefore, weightage of the circumstances is more important, especially during the lack of direct evidence in this case. So, all the cumulative circumstantial evidence are strong enough and also have a great weightage in order to prove the motive, the intention, and also the mens rea of the appellant to commit the murder. In Director of PP against Kilburn, circumstantial evidence works cumulatively in geometrical progression and also to eliminating other possibilities. In conclusion, this case of Sunny Ang against PP is a case which wholly relied on circumstantial evidence instead of direct evidence. From this, I can conclude that direct evidence is not necessarily needed to prove certain existence in a case, as this case is happened and tried in an era which prior to the abolishment of the jury system in Malaysia. The jury remarks are very important and also vital during that time, because it may influence the decision by the judge. However, in the era today, judges is the only one who consider the weightage of circumstantial evidence without any interference by the jury. So the question poses here is whether the cumulative effects of all the evidence lead to the irresistible conclusion that it was the accused who committed this crime, because there might be some of the reasonable possible explanation shall have been considered by the judge. For example, it is just an accident, mere coincidence, or even the act by God, but not the conduct by the human being. Is the totality of all the circumstantial evidence lead to the conclusion or inference of the commitment of the crime? to consider it all together, but not merely only each one of them. This is the answer. And also, it shall also lead to the irresistible inference and also conclusion that show the accused was the one who actually commits the crime. I can say that all in all, actus reus may only be proved by direct evidence. However, the mens rea, the motive or intention can solely depend on the circumstantial evidence which leads to the commitment of the offense, as just narrated in this case of Sunny Ang against VP. And that's all from me. Thank you, sir.